Professor Fredrickson, can you tell us what specific prohibitions or guardrails you think must be included in any code which the justices may adopt?
Well, thank you for that question. I think the guardrails that this committee has included are very significant ones. I think limitations on the ability to accept gifts, very important disclosure rules, and recusal. Recusal has to be something that actually really applies more forcefully to the justices. That is, there needs to be a policing mechanism that doesn't exist right now. Right now, the justices are the only judges in their own cause. They decide themselves whether to recuse, and there is no oversight mechanism of that. The court should be directed, as this committee's bill would do, to develop its standard and a policing approach where there would be some review by the court as a whole.
Let me just ask you very quickly, if the court didn't do that, would you think it proper for Congress to impose a code?
I think it would be far more preferable were the court to do it itself for many reasons, but I do believe that Congress could also do so.
Thank you. Reverend Schenck, what was the purpose of working to embolden conservative Supreme Court justices, especially when you suspected that they already agreed with you?
Thank you, Mr. Chairman. We're all human beings, all cut from the same cord. If there's anything I've learned in 45 years of ordained ministry, it's that we all suffer similarly, we all have similar weaknesses, and when I arrived at the Supreme Court in the late 1990s, at least my fellow conservatives and I had convinced ourselves that the conservative members of the court were beleaguered. They were disfavored. They were routinely maligned and insulted in the public arena. And we thought they needed some shoring up. And we also were concerned that some of them had assured in their testimony during confirmation hearing that Roe v. Wade was settled law, and that maybe, just maybe, other forces could work to intimidate them from coming after Roe. And so we wanted to create a circle of people around them that would encourage them, applaud them, literally thank God for them and assure them of prayerful support, and by being present, indicate to them that there were many, many Americans who were behind them and hoped that they would render strong, unapologetic, unequivocal opinions that would support the positions important to us.
Thank you. And briefly, can you describe the major differences you faced when conducting outreach to members of Congress or the executive branch versus the Supreme Court? And how did that factor into your organization shifting its attention to the Supreme Court?
Yes, well, of course, with the other branches, there were clear rules in place that limited the way one could interact with the representatives of those branches. This body in particular, because we were aware that there were limitations on gifts, for example. When you took someone out to dinner, you had to be careful who can pay for this. And when it came to honoraria for speaking engagements and so forth, but none of that applied at the Supreme Court. We knew that there was a great deal of liberty and latitude there, and made our operation at the judicial branch at that level much easier.
Thank you. My time has expired.